It's actually fraudulent word that was since been signed by a judge. I have lawsuits filed on all of this stuff right now, which I know that they received.
Hold on, brother. Wait. I'm just asking you to have a seat at the chair with a microphone.
Oh, I understand that. I'll do it. Okay. The front seconds up here.
That's fine. Just make sure you're talking to the microphone.
Absolutely.
Okay. All right. You can sit down. Okay. So I think this is your motion to dismiss, right?
Yeah, I have a few in there that I've been repeatedly trying to be dismissed.
Which one do you want to start with first?
Well, the recent one I filed, the motion to reject the swearing in and all that, based off the fact that, like I said, I was sent a default motion that I don't know how it even got sent out past the day, but it was never signed or anything. I was also defaulted out the fact that there was a citation. I never even presented a court appearance.
Okay, hold on. You're giving me too many issues. You're talking about swearing in. You're talking about a default judgment. Just pick one issue. We're going to deal with them one at a time. So what do you want to deal with first? You want to deal with the default?
Well, yeah, the default.
Okay, so was that on the civil infraction, failed to disclose the CPL?
I suppose that's what it was under, yes.
Okay, don't suppose, it's your motion, brother. Tell me what it is.
Well, it keeps getting
that's the only civil infraction.
I have numerous, I have lots of stuff.
Hold on, that's the only civil infraction I see with your name on it. So I'm just confirming that we're talking about that charge.
Yeah, sure.
Okay. So do you know why the default was entered? Did you miss a deadline? Did you
I was notified. I was called by people that I know within Huron and the police chief stating that I had a missed appearance date. I never had an appearance date scheduled, but I went back looking at the citation. There was no date. And actually how fast it got issued raises real concerns to me. And then once I received the default in the order.
Hold on. Let's take one thing at a time. So you said you never got an appearance date.
Correct.
Do you have a copy of the ticket? Because I've got a copy.
Yeah, I said it's in there. It's attached to my motions.
Okay, do you have a copy of the ticket?
I do.
Okay, then I'm going to ask you to look at that copy of the ticket, because my copy of your ticket says contact court for appearance date.
It says contact court for appearance date, where it says appearance date on or before. There's nothing.
Okay, but it says contact court for appearance date. That means the monkey's on your back to contact us.
I will also on the bottom of the tickets it says if you fail to contact court within the specified amount of time. There was no specified amount of time on here. I had no idea when I was supposed to contact the court. I was dealing with trying to get my attorney.
Let me ask you this: did you contact the court?
I was again, as I said, I had no sort of.
All right, strap in, because today we're stepping into the courtroom of one of the strictest judges ever featured on this channel. Judge Oakley is not the kind of judge who tolerates rambling, circular arguments, or internet law nonsense. If you waste his time, he will absolutely make you regret it, financially, procedurally, or with a shiny new contempt. Believes paperwork, buzzwords, and accusations of fraud can magically override court records and procedure. He thinks motions cancel consequences, defaults violate due process by default, and that confusion equals victory, but this courtroom doesn't run on vibes, it runs on yes or no answers, timelines, and responsibility. Watch how the judge repeatedly tries to slow the conversation down, isolate one issue at a time, and give the defendant every opportunity to explain himself, and watch how the defendant repeatedly sabotages himself instead.
This is going to go a lot easier on everybody if you just answer the question I asked. I'm going to give you plenty of chance to give me any argument you want to give. Okay? So don't feel that you have to force your argument into every question I ask. The question was, did you contact the court?
Well, Your Honor, I would have contacted the court if I had a specified.
That's a yes or no. So I'm going to take that as a no. You didn't contact the court. So after 14 days on a civil infraction, if we don't hear from the defendant, we enter default.
It was less than that, actually, when I was defaulted, Your Honor.
Less than that from what?
From whatever this was issued. And like I said, I was contacting.
Well, once again, I'm going to draw your attention to the ticket. My ticket, which I think is the same one you got, is dated February 3rd.
Correct.
Okay, so that's when it was issued, February 3rd.
Correct.
So when was the default? When did you get notice of a default?
Actually, I know I got the thing in the mail. When did I get this? This says that, I don't think it specifies a date.
Well, did you make a note when you received
this? This said I had I don't remember exactly what date I received this in the mail, but this was scheduled for March 8th.
Okay.
So that was even less than a
But what is that's scheduled?
This says it was for my order, the motion affidavit saying that I was defaulted and saying that I needed to pay bond and an orange warrant would be issued. And I said,
Okay.
again, that was never.
And that's dated what?
This was dated 3/8. That I needed to appear
Okay.
on or before 3/8.
Okay, so that was March 8th. You were defaulted February 22nd.
Okay. Which then, again, there was no dates. I had no nothing. I had no
Okay.
notice of any sort of.
Once again, you're not hearing what I'm telling you. The monkey was on your back. The ticket clearly said you contact us. You never did.
And it also specifies right here, if you fail to appear by the date specified, and then on the bottom one, even for the other one, if you fail to answer a citation by date specified, there was no dates.
Okay.
There was no.
Right away, we hear the word duress, a favorite among sovereign-style litigants. And almost every time it's used, it's meaningless. Duress isn't feeling uncomfortable. It isn't feeling outnumbered. And it definitely isn't believing everyone else in the room is less intelligent than you. Legal duress requires coercion, threats, or unlawful pressure, not disagreement or frustration. But instead of explaining how he's under duress, the defendant uses it as a conversational shield, hoping the phrase alone will invalidate the proceeding. What's happening emotionally here is important. The defendant is already positioning himself as the victim before any ruling is made. That mindset makes it almost impossible to accept responsibility or acknowledge procedural missteps later, which is exactly what's.
Whether or not he showed up.
Which I object to the setting
Sir,
aside.
do not interrupt the lady. Did she interrupt you?
No.
Then don't do that. Let's be civil. Go ahead.
Thank you, Your Honor. Judge Green, Mr. Purcell did bring it up again with the Honorable Judge Green, and she declined or denied his motion based on the fact that it was moot because Judge Martin set it aside.
So the default's already been set aside.
Yes.
Brother, why'd you just waste 5 minutes of my life?
Since March 14th, Your Honor.
Which I object to that because they.
You object to your motion being
No, I
granted?
object to them setting aside my motion. And I object to.
No. Wait. Listen. She tells me Judge Martin set aside the default based on your motion.
Yes, but I was never told any of that prior to any of that.
So you want to argue about the fact that you got what you asked for?
No, what I'm saying is the fact that the due process was violated is what happened in this whole problem. When I was defaulted, due process was violated.
So what? She set it aside.
Listen, it was set aside to cause damages to me because of what happened with the default.
Well, explain to me how you were damaged.
First off, there's threats made against me, right? Clearly, he's threatening me to issue
No.
warrants,
I didn't ask you
threatening to
about
pay
threats.
money.
I said, how were you? You said you were damaged. I'm asking you, what was the damage?
The fact that I was threatened to come in and pay money or warrants.
How was that damage?
And I was being threatened by Huron Police, which I have on record.
What's the damage?
What do you mean? The fact that I had to come in and pay money, or I would have been, they'd have been issued.
What money
warrants.
did you pay?
Huh?
What money did you pay?
$280. I had the receipt and everything. It was all attached to my motions. They just keep trying to set it aside, and Judge Green never said a word to me about any of that.
It's been set aside. Counsel just said, Judge Martin set aside the default. So what that means is procedurally, it's like it's a brand new file. Understood?
Yeah, but that's according, yeah, but that, especially now with the new Chevron overlay, that's
This is where Judge Oakley starts doing what experienced judges do best, controlling chaos. ***. The defendant throws out a buffet of complaints, unsigned orders, default judgments, citations, appearances, swearing-in issues, all at once. And the judge shuts that down immediately. Courts do not operate on scattershot arguments. You don't get to overwhelm the system and hope something sticks. Judges require one issue at a time because clarity is power in a courtroom. The defendant doesn't understand that by refusing to focus, he's not strengthening his case, he's weakening it. Every time he jumps topics, he signals confusion rather than competence.
so it was decided the money should be returned, correct?
Well, I don't know. Did she address the money?
No, she never did. No one did. It's
Sir,
written in my motion.
Sir, I'm going to hold you in contempt the next time you cut her off. The first contempt, $100. The second contempt, a day in jail. Are we clear on the ground rules for my courtroom? Is that a yes for the
Yes, Your
record?
Honor.
Okay. I'm giving you all the time you need to talk. Don't talk over her.
Okay, understand. I'm sorry. There's just been a lot that's been going on with this.
And I'm the first time I'm seeing it, so I'm trying to get to the bottom of it.
You're right.
All right. So we started with what motion do you want to talk about first? You said your motion to set aside the default. That was granted by Judge Martin, is what I'm hearing from the prosecutor. So that motion's done. Would you agree?
As long as my money gets returned, then I guess it's taken
At
care
some
of.
point, trust me, your money will either get applied or returned. Next motion you want to talk about.
The dismissal based off the fundamental violations of my fundamental rights and due process.
Okay, well, tell me more.
Okay.
Do you have, hold on, let me just cut to the chase. Do you have more than just the fact that you think you have a right to travel?
Yes, Your Honor. Actually,
That's denied. I'll just cut to the chase. That's denied. I don't buy it.
The turning point most self-represented defendants miss. The ticket says, contact court for appearance date. That phrase doesn't mean wait star. It doesn't mean asterisk guess. And it doesn't mean argue semantics later. It means the responsibility shifted entirely onto the defendant. The judge spells it out plainly. The monkey is on your back. Courts are not babysitters. If a ticket instructs you to contact the court, failing to do so is a choice, not a defense. Ironically, the defendant may have had a potentially valid procedural argument regarding missing dates. But instead of presenting it cleanly, he buried it under excuse.
I've denied that motion. We're not going to talk about that motion because I've denied it based on your argument that you have a right to travel and don't need a license. Is there anything else you want to hang your hat on for dismissal?
well, I do object to the setting aside of my motion, Your Honor.
I'm not setting aside your motion. I'm denying your motion.
Well, denying, I object to the
You
denying.
can't
of my motion.
object. You can appeal.
Well, I'm just
Okay.
letting you know, I'm stating for the record that I am objecting to your denial of my appeal.
That's fine.
Okay.
Circuit court judges have bills to pay too, right? So you appeal me to the circuit court. Do you have any other argument why these cases should be dismissed?
Yes, absolutely. Well, honestly, Your Honor, like I said, I even have both lawsuits. They've received my lawsuits to the Huron Township Police Department overall.
Hold on. I don't know anything about lawsuit. How would you suing the township work as a reason to dismiss these charges?
Because the initial traffic stop and everything was an unlawful stop from the get. I was
Okay, but that's got
retaliating.
nothing to do with your lawsuit. That might be the basis of your lawsuit. So you want to talk about whether or not there was a valid reason for a
Yeah,
stop?
absolutely.
Then make the argument.
Yeah, Your Honor, so prior to me being pulled over by this officer, I was actually in contact with several law enforcement officers that are friends, and actually two that are currently working within Huron that had confirmed I had every lawful right to be doing what I was doing. The one even pulled up to me and my wife at a gas station in town, and we are in Sibley and Middlebelt, right near actually where I got pulled over, and we had discussed it and talked about it and went on about our day, and this was all prior to this incident. I had two other interactions with this officer where I had specifically told him, I've already been confirmed and doing lawful, I'm well within my lawful rights. I have it documented. You need to go talk to the sergeant that I've been talking to and a couple other buddies, right? I gave him that opportunity. It was shortly after that. And I had that confirmation well prior to me even being pulled over. Okay. So then, this officer seen me leaving my house, pulling off my dead end dirt road, proceeded. Like I said, I even told him, I've already had this, I've already used this. You need to go talk to the sergeant.
Right.
Chose not to. Pulled me over, walked up, just started demanding ID and everything from me, and wouldn't identify himself, none of that good stuff. And then now this is where it's all led to. And I informed him, I have body cams, I have my own recording. And like I said, I have a lot.
Okay, but you started out by saying you wanted this dismissed because there was not probable cause for the stop.
Correct.
Okay. And then you went on to tell me how there was obviously a difference in opinion within the department about whether or not what you were doing was legal or not.
Well, I
Is that
specifically
a fair
stated.
summation?
What was that?
Is that a fair summation of what you just said? Some of the officers that you talked to said you could do that, and obviously the officer that wrote you the ticket didn't think you could.
Correct.
Okay, so that's a difference of opinion there, which has very little, if anything, to do with the probable cause for the stop. So I'm going to.
This exchange is surgical. The judge asks a single, deadly question, did you contact the court? And instead of answering yes or no, the defendant tries to explain why he didn't. Without admitting that he didn't, judges ask yes or no questions for a reason. Once you dodge them, the judge is allowed to answer for you. And that's exactly what happens here. Notice the shift. The judge stops debating and starts finding facts. No response becomes a no. And once that's on the record, everything else collapses.